Now, your question is actually quite interesting. It's very, very strange, but I can imagine that it applies frequently. Now, in terms of some leases, a landlord is entitled to terminate a lease agreement early under special conditions. And this is contained in legislation, but it has to be exceptional circumstances or defined circumstances. So it has to be justifiable. So some lease agreements actually allow the landlord to terminate a lease if they want to move into the property or they want to sell the property. Why? Well, obviously, it's to better their position. Some people that want to buy a property want to live in it. So why would you want a tenant? Or you want to live in it? Why would you want a tenant there? So it gives you some rights. So what happened here is that notice was given by the landlord, and the tenant accepted it, went out, found another property, and said, "Great, you know what? I found it before the 2 months lapsed, before the notice period lapsed. So I'm going to move out now as opposed to later." And unfortunately, here, landlord wasn't too happy about that because he missed out a whole month's rent, having given 2 months' notice, and now the tenant left 1 month earlier. Question here is this something that the tenant should be liable to pay for?
Perfect. Thank you, Bruno. So we're dealing with two different things here. So I want to deal with a little bit of, in this question, the notice that the landlord is given. As Bruno pointed out, 2 months notice, the landlord said he's going to move into the premises. This is a common clause that's included in a lot of lease agreements, particularly the TPN lease agreement, which we're a big fan of. This is a condition that's written into that lease agreement. Why this specific clause is in the agreement and why it can be forced is in terms of sections 45C of the Rental Housing Act. And what 45C says is the parties can agree, okay, to terms to bring the lease agreement to an end, provided that it's in writing and it doesn't constitute an unfair practice. Okay, so it's got to be in the lease agreement and it's got to not be an unfair practice. An unfair practice, please remember, is up for the determination of a court at this point. So, this is something that's written into the agreement, and we're pretty comfortable that it doesn't constitute an unfair practice in the circumstances. So, the landlord gives notice in this particular case, and as Bruno has pointed out, what the tenant then does is they say, "Fantastic, I'm actually going to move out early in the circumstances." Now, what's important to note here is when a lease agreement is terminated, okay, either by the notices we're talking about in this circumstance, or say that your lease agreement is running on a month-to-month basis, and you give a month's notice to terminate the agreement. When an agreement is terminated, it does not mean that lease agreement ends on the date of the notice that is given. The lease agreement only ends at the end of the period for which you have given. So in other words, the month or the 2 months that you've said, "I'm going to bring a lease agreement to an end" at that point. And what that means is during that notice period, the lease agreement itself is still absolutely in place, valid, okay, and enforceable between the parties. Nothing changes. The lease agreement is just going to end at a future date, which has been determined. And so all parties retain their rights and responsibilities in terms of the particular agreement. And insofar as any legislation is applicable to that agreement, it still applies to that agreement. Nothing changes during that notice period. So what's important for the purposes of our question here today is the landlord has given a 2 months notice to bring the lease agreement to an end. Okay, that lease agreement is still in place in terms of a fixed term agreement that has been agreed to between the parties. Its end date has just been moved up. And so in the circumstances, a tenant still has the ability, in terms of the Consumer Protection Act, Section 14, which we love, to bring a lease agreement to an end prematurely, subject to a reasonable cancellation penalty. And this is how I've argued my way through this particular question, because while the landlord, if we were dealing with a commercial tenant where there's no ability whatsoever to terminate an agreement early, this argument may change. The landlord might be able to sit on a position and say, without a doubt, you're liable for that last month's rental. There's definitely an argument to that effect. But this particular question dealt with the residential tenants. The residential tenant has been given notice to move out in 2 months, and he effectively cancels the lease agreement before that 2 months notice to say, "I'm actually going to move out prior to the notice that you've given me. In those circumstances, the tenant is affecting his right in terms of Section 14 of the Consumer Protection Act. He must give 20 business days notice, and he is subject to a reasonable cancellation penalty. And as we have dealt with on this channel many, many times, what constitutes a reasonable cancellation penalty entirely depends on the facts of the case. So this is one of those rare circumstances. Normally we'll talk about how long the lease agreement has to go, what the rental looks like, what is the ability to place a new tenant in occupation of the particular premises. In this circumstance, the overriding circumstance that would be looked at is landlord, yes, he's brought the lease agreement to an end a little bit earlier, but it is in the context of the fact that you have already given him notice that he had to move out of the property. And in fact, he has just accelerated that because you have already given him notice. And that is a circumstance which I imagine would have to be taken into account when determining what a reasonable cancellation penalty is. And from my perspective, when I was talking to the client about this particular problem, I actually said to the client, I think you would have difficulty sitting in front of a court and saying to the court, well, I told the tenant to get out within 2 months and he did it within a month. And now I'm seeking a reasonable cancellation penalty in the circumstances. That is a circumstance that the court would have to take into consideration. It is something that, as I say, we're talking about the Consumer Protection Act here, so that the court is looking for a way to protect the consumer of a service in the circumstances. And so I think you'd have difficulty with an argument to that effect. So it's just another key highlight. It's a very particular situation, but very, very nice for highlighting exactly what to look for when we're talking about cancellation, reasonable cancellation penalty, and the parties' responsibilities there too. Perfect. And that brings us to the end. Thank you very much, Bruno. We will see you next week.
Awesome. Have a great one.
Cheers.
Cheers.